invite Deputy Roderic O'Gorman, 7 minutes.
Thanks, Chair. Good morning. I'd like to start maybe looking at Head 12. And our Climate Act contains a key section that requires every body of our state to undertake its functions in a manner that's compatible with our climate obligations. And we saw the importance of that section of the Climate Act in the recent Supreme Court decision in Coolglass. And it's very much the linchpin of the Climate Act and our overall efforts to reduce our emissions. And Heading 12 in this bill is a really sweeping carve-out of that, and in my mind undermines our response to climate change, and it effectively permits things to happen under this bill that would otherwise contravene the state's obligations under the Climate Act. So could you explain why Head 12 has been put into this piece of legislation?
Okay, thank you, Deputy. Firstly, international aviation emissions are actually outside the scope of the Climate Action Plan targets, as I'm sure you're aware. And also, I think an important point here is that the passenger cap that's currently in place is not a targeted climate measure. However, the Minister is committed to balancing the clear benefits of the aviation sector with sustainability actions, and has ensured that the legislation integrates environmental assessment and mitigation into decision making in advance of making an order. There are a number of, I suppose, actions being taken internationally, particularly under the ICAO basket of measures to address international climate.
If you mind me just coming in there, because I'm aware of that. I suppose if our international emissions are outside, yes, and the passenger cap isn't a specific climate measure, it's not. Why then is there a need to exclude the application of the Climate Act? Because if they're not, if this aviation emissions are already not considered here, why do we need to take this step?
It's, I think, for the avoidance of doubt, really, and on the basis of legal advice, we have decided to include a derogation.
And that avoidance of doubt, had you asked for that clarification, or was that advice you received from the Office of the Attorney General?
We have received so much legal advice on this, I can't recall.
Could you come back to me maybe on that point in writing? Yeah. I suppose I'm just concerned because I noticed an almost identical provision being put into the legislation dealing with the strategic gas reserve coming from the Department of Climate. You've a slightly different phraseology used there. Is that deliberate?
Well, obviously this will have to go through formal legal drafting. This is just the general scheme at the moment, and the Office of the Parliamentary Counsel is looking at the formal legal drafting at the moment. So that the current wording obviously will be finessed and finalised in that context.
Is the reason this provision has been put in because the function or the process to adjudicate whether removing this cap would have climate impacts would take too long and elongate a process that the department wants to be short? Or is it because you felt there was a risk of a subsequent judicial review for the action not being compatible with the Climate Act?
I think in both scenarios, really, because obviously there are strong feelings about this issue on both sides, those who wish to see the cap removed and those who wish to see the cap remain. I would repeat, though, that it's not, the cap wasn't introduced as a targeted climate measure. Our other airports, Dublin Airport, traffic at Dublin Airport has been growing. Our other airports have been growing traffic as well. And there are no caps in place there because, as I said, the international aviation emissions are outside the scope of the Climate Action Plan targets.
And does any climate analysis take place? So am I right in saying now that there will be no climate analysis taking place on this decision if Heading 12 is maintained in the legislation?
The environmental assessments for both EIA, water framework and habitats will be screened by ACP screening assessments will be undertaken.
But they're
and
not
if necess- and if necessary,
climate-based assessments,
full-
am I correct?
Yes, but full environmental assessments then will be undertaken if assessed necessary by Bord Planola.
Heading 11 here provides for a judicial review of a decision and a timeline within it. Do you mind me asking why heading 12 therefore means a judicial review can't take place on the climate grounds? I'm just not clear why. There will be a range of reasons why people might take a judicial review on this case. I'm just not clear why, of all of them, the climate ground is being explicitly excluded. Why was climate explicitly excluded as a grounds, which is the consequence of heading 12?
Because it has the derogation, there's a derogation from the Climate Act.
But I suppose I'm just wondering why was the one issue of climate excluded? Like, judicial review of a decision on the cap is provided for here under heading 11. Heading 12 means that a judicial review on the basis that it breaches the Climate Act isn't possible. I'm just wondering why was that choice made by the department that climate is excluded as an issue for judicial review, whereas other issues like compatibility with the EIA, anything else is okay.
Sorry, I just consulted.
Yeah.
I suppose just to mitigate the risk, really. As I said, judicial review is provided for, and the timeframes within which the judicial review must be taken, and then the specific derogation that has been included on the basis of legal advice as well.
And has your department done an analysis that indicates that if heading 12 wasn't there, there's a strong chance that the actions taken under the removal of the cap would breach our obligations under the Climate Act? Have you done some analysis that causes you to put heading 12 in as a protection against a particular judicial review on a climate ground?
No, we haven't done that analysis.
Okay, thank you.
Substituting for Deputy Louis O'Hara, I now ask Deputy Louise O'Reilly to intervene.
Approved.
Thank you. Deputy O'Gorman. 5 minutes.
Thanks, Chair. I'm just wondering, as a kind of a policy goal, does the Department of Transport have a policy on the target number of passengers that it wants to see go through Dublin Airport on an annual basis?
No, we don't, Deputy. Our national aviation policy, which admittedly is 10 years old now at this stage, the published policy dates from 2015, and there is a commitment in the programme for government to review that, and that is a body of work that we are getting underway in the department. But it has never been the case that we would be targeting particular passenger numbers, because it is, after all, a fully liberalised market, so it's up to.
And you would expect that same pattern will be repeated in the new national aviation policy? There won't be a target set for Dublin Airport in terms of yearly passenger numbers?
Well, I wouldn't wish to predict what we might arrive at, because obviously we'll have to consult as part of that policy development process. But in the past, no, we haven't set a target.
In terms, so let's say then you don't have a target to reach. Does the department as a policy have an upper limit on the number of passengers that, as a policy, it would like to see going through Dublin Airport on a year?
No, we don't.
So you're kind of value neutral on that point. Just in terms of, so I suppose like DAA are now seeking a change to the original condition for 40 million. The Minister has cited 60 million as a figure that he has in mind over a period of years, bringing Dublin Airport similar to what JFK Airport in New York did in 2024. But that's not something the department has a particular view on. Those are the DAA opinion, the political opinion of the Minister. It's not a policy. The 60 million isn't a departmental policy.
No, it's not. And there have been references to, 50, 55, 60 million. DEA, as part of its master planning, will be looking at various scenarios, but that's in terms of capacity as opposed to a policy target.
Right. In terms then of balanced regional development, is any analysis undertaken when the cap is removed about new routes that may have gone to other airports in Ireland but will now go to Dublin Airport? Is there any risk that new routes now won't go to Shannon or Cork but will come to Dublin? Is there any analysis undertaken of that?
No, not at the moment. I mean, it is, I suppose, reasonable to assume that where capacity constraints exist, airlines will move that capacity elsewhere, but you will have
And then
you will have heard the airline say that that might not necessarily be Cork or Shannon. It could be Manchester or Birmingham in terms of airline decisions as to where they position aircraft. They'll position aircraft on routes that can obviously make the highest return for them.
And if I can maybe turn that around then, if capacity constraints are removed, have you undertaken any analysis that existing routes that are going through, for example, Cork or Shannon, may now be rerouted through Dublin if there's additional capacity when the cap is removed? So have you done an analysis as to whether airlines will make a strategic decision to reduce services in some of our other airports and move them to Dublin?
Deputy, respectfully, I wouldn't second guess airlines in terms of commercial decisions that they would make.
No, I understand that, but just in terms of undertaking a piece of analysis, like we are making a very significant policy change to Dublin Airport, and I think we as legislators need to understand, as legislators who believe in balanced regional development, will there be a knock-on consequence for that policy change to our other airports as well, and passengers wanting to go through those airports? I suppose I would have thought maybe there would be some element of analysis to see what will the knock-on impacts of this be on the other regional airports.
I'd portray it slightly differently. I mean, what we're doing here is not a policy change. Our policy, as set out in the National Aviation Policy, has always been to see the sustainable development of Dublin Airport and to support its development as a secondary hub airport. So that is policy.
And
this is a planning condition.
A final question. The National Aviation Policy, did that specifically reference removing this condition?
No, it was written in 2015 when 32 million wasn't, on the horizon in terms of a breach.
For 8 years, though, at that stage, hadn't it?
It had, yeah. And DEA, as the statutory authority for developing the airport, would have been looking at what it needed to do in terms of its future planning.
This wasn't a matter of concern in 2015?
No, it wasn't.
Thank you.
Thank you.
Thank you. You talked about the role